Hi, everyone. Thank you for joining today's webinar presentation, The Art of Responding to Obviousness Rejections. I'm Allie Morton, the Product Marketing Manager at LexisNexis IP, and I want to cover a couple things before we get started today. Anytime during the conference, please feel free to submit questions in the little question box, and we will answer them as we go and then make time for them at the end as well. Also, you can download a copy of the slides from the GoToWebinar panel, and then a link to the recording from today's presentation will be sent out via email after the presentation. Now I'd like to introduce today's presenters. We have Gene Quinn, the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Gene was recently named one of the world's leading IP strategists by IAM for the second consecutive year. Also joining us, we have John White, who is a U.S. patent attorney and patent lecturer. He is an adjunct law professor at the University of Virginia School of Law and a principal lecturer and author of PLI Patent Bar Review course, a course that he originally created. John also serves as an expert witness in patent litigations and is regarded as a leading authority on patent practice and procedure. Then rounding out our presenters today, we have Megan McLaughlin, who is a product director at LexisNexis IP and previously worked as a patent attorney at a large law firm. Megan has a bachelor's degree in bioengineering from Rice and a JD from Harvard Law. Thank you, everybody, for attending today's presentation. And with that, I will turn it over to you, Gene.
Okay, thanks a lot, Allie. I really appreciate it. And thank you all for spending a portion of your Thursday here with us today to talk about obviousness. And this is an encore presentation. It probably won't wind up being exactly the same presentation because we don't do this with a script, and we do let your questions drive where we're going to go with the presentation. And I have changed some of the slides up, and we did get some questions emailed to us in advance. So we have a couple new slides to address some of those issues that have come up. So we're looking really forward to getting going. So we have a lot to cover, so let's just begin. There is one little thing here from the Shameless Commerce Department. We have another webinar coming up with LexisNexis at the end of the month, and this is going to be a really good webinar. I'm really excited. It's about 101 problem for artificial intelligence. So if you're dealing with 101 issues, you're going to want to really come to this webinar because there, as it turns out, Kate Gaudry, who you may know, she's written for IP Watchdog a number of times, and she speaks on 101 a lot. She's identified an inflection point. It's pretty remarkable. And now, believe it or not, artificial intelligence related inventions are as likely to get rejected under 101 as are pure business method patents, which is just remarkable. So we're going to talk about that and what we can do with it. So that's coming up. So I want to make sure everybody knew about that. I'm looking really forward to that one. So we're going to pause here as we always do at the outline, and we're going to bring in our panel for the first time. And we'll start with John, and Megan, I'll ask you the same question. Before we embark substantively on this conversation about obviousness, what is it that you think everybody needs to keep in mind substantively? John?
My advice, and this stems from being an examiner way back when and having responded probably to thousands of 103 rejections over the past 30 years, is bear in mind the examiner situation when they're assembling a rejection. They're looking at the entirety of the application for the first time. They're, scoping it out for 112 issues, A and B paragraph and so forth. They're understanding the claims, they're doing a search, and they're cobbling together a rejection. And the one thing that gets short shrift is reading of the individual references. And so they may piece something together and facially it seems to make sense, but what they've been unable to do is really drill down, understand what the reference discloses in its entirety, which is something they should do, but literally don't have time to do. And luckily you do. And so my advice to anybody responding to 103 is don't take the approach the examiner has, which is just, titles and subheadings and a few cryptic quotes out of the reference. Read it and find out what's really going on in these things, and you'll find out a lot in terms of being able to undermine and argue back to the examiner that the rejection just doesn't hold up under KSR.
All right, thanks, John. Megan, what are your preliminary thoughts on this?
Yeah, so along the same lines as John, I would say absolutely consider your examiner. So I spend most of my day every day looking at aggregated U.S. Patent Office data, and I can tell you that there is significant variability at the Patent Office, both across technologies and even within individual art units. And so when you're responding to an obviousness rejection, you're going to hear today a lot of different legal arguments and strategies that you can use. And all I would say, and one of the things that I want you guys to take away is that you have the ability to customize your argument for a particular examiner in a particular art unit. And I'll be talking about some of the ways to do that.
And that's where we're going to lead off the webinar here. Megan, you're going to drive us for the first few slides and kind of lay some of the predicate that we're going to talk about throughout the webinar. So can you take it away?
Yeah, so if you guys are here, it's because you've been the victim of a 103 rejection. And so
I like that. You're a victim.
You're the victim. And this probably won't come as a surprise, but getting a 103 rejection is both incredibly common and incredibly detrimental to prosecution outcomes. So in most art units at the USPTO, an overwhelming majority of cases actually receive a 103 rejection. So I just picked a random art unit by way of example, 1711 for cleaning and liquid contact with solids. In this art unit, 80% of applications have received a 103 rejection. So what I did was I divided those groups of applications into two buckets, those that have received 103 rejections and those that haven't. And immediately, and again, probably not terribly surprising to anyone on this webinar, those cases that did receive 103 rejections had a lower allowance rate, so a lower likelihood of actually getting patent issuance and a longer time to allowance. And just for reference, I've also included charts that show the other types of rejections that each of these applications has received. So you can see, really the only difference in these two buckets was the presence of a 103 rejection. So if you could go to the next slide. So that's your average art unit. But I think what will surprise you is how bad getting a 103 rejection can be, particularly in some art units. Yeah. So let's look at another art unit in the business methods portion of 3600, 3628. This is a place that nobody wants to end up because it's likely to get lost. It's likely to get Alice, right? But also there's another hidden danger in these art units, and that's the 103 rejection. So here, even 90% of applications have gotten a 103 rejection. And of those applications that did receive a 103, the allowance rate was a pathetic 17.9%, and the average time to allowance was 5 years. Oh so allowance rate dropped by almost 10%, and the time to allowance went up by about a year and a half. And here's what I think is the most interesting about this data is notice how the percent of 101 rejections is actually lower in the 103 group, and yet even still the allowance rate here is worse. So if you could go to the next slide. And there's variability here, right? Every art unit's a little bit different. You'll see some examiners like examiner Rule who actually don't issue that many 103 rejections versus examiner Allen who issue a ton. So there's variability, and this just drives home the point that I made earlier, which is that in any situation, but particularly with 103, it's really important to know who your examiner is and what art unit you're dealing with. But the basic point of all of this data is getting a 103 rejection is common and it's bad. So now I want to turn it over to John and Gene to tell you how to deal with this.
Yeah, the short of it is you just don't want to get it if at all possible. So we'll work our way there. The first place where you have to start any of this is just with John Deere, and here's the site, and we don't need to belabor this because everybody on the call knows about it. The interesting thing here that I think, and based also on the number of questions that we got during the last webinar, is in looking at the cases and where things are headed, I think this the secondary considerations rather is going to be an area where there's an awful lot of play moving forward into 2019 and beyond. because there seems to be a tremendous disagreement as to the role secondary considerations plays in the obviousness inquiry. And John Deere Graham versus John Deere did not say they were mandatory. It said they may be useful, and the Federal Circuit has always said that they are required, and now there seems to be panels that are backing off of that. So let's just get to it and talk about it. I mean, secondary considerations are really not all created equal. Some of them are more equal than others, I suppose, and it's all about the facts of the case. And there is a certain amount of overlap between secondary considerations and KSR in some ways, which kind of makes me wonder why we're having some of these problems, because they do seem to go hand in hand, John, don't you think?
Well, I think the difficulty with Graham versus John Deere is it tried to come out of the box and take something that is inherently subjective, just by its nature, obviousness, and turn it into something objective, that there were standards and thresholds and facts to be found and judgments to be made. And so it's a hard thing to do, right? And so I think secondary considerations give you some insight into the likelihood that your original assessment is correct. If it's so obvious, why wasn't it done previously? Why have so many others failed? And why are so many copying? It's because that would point to, well, maybe your assessment that it's obvious in light of the prior art and the differences and the skill in the field is just flat out wrong. I think secondary considerations are vital at the moment. They've always been vital, but they're more vital, it seems now, because the 103 rejections are so loosely assembled. Secondary considerations perhaps can push back against them.
Yeah, and we're going to get to this in a little bit more detail in a couple more slides, but you can't just wave the magic wand and say secondary considerations. There really needs to be that nexus. It's not that the invention just has never existed. It's why has the invention never existed? The invention has never existed despite the fact that others have really tried to find a solution. That's where you wind up really getting some benefit out of secondary considerations.
Well, the other thing that's difficult is the lag time between filing and examination. If you file initially a provisional application and thereafter file a non-provisional, and 3 years, 4 years go by, well, a lot of things end up being obvious in 4 or 5 years that aren't now. And that's a problem, because an examiner is examining it with information in their head that they've been learning steadily over the past 4 or 5 years since you did this. And they can't help but say, well, everybody's doing this. And you go, well, not then, not when I started, and that's why we've had such commercial success, because when I initially put this on the table, it was unique, and now it's been widely adopted, but that doesn't take away from the initial unobviousness of this and the fact that you should get a patent.
See, now I'm going to jump around here, and I don't normally like to do this, but at least as far as I'm going to go, I'm going to jump all the way to our slide number 36, because something John just brought up, maybe, and this was not on our original slide deck. I put a little bit more in here about obvious to try, and I found this case, Leo Pharmaceutical Products versus Ray, and this was a decision by Judge Rader. And I'm jumping into this right now because I think the more that you spend time looking at the law of obviousness, it folds over onto itself. There's not a number of buckets. The courts in some ways have tried to make this like pigeonhole this, and it has a bunch of different buckets where you have a bunch of different things you're considering. But at some level, it's completely subjective. It's in the eye of beauty's in the eye of the beholder. And a lot of these concepts fold over onto themselves. And it's really hard not to notice how obvious to try considerations are in some way intimately related to secondary considerations, right? So when John said the lag time between the prior art, that's why I jumped to Leo, because what the argument was here was this was obvious to try. And what the board did was they put together a whole bunch of different pieces of prior art, and that prior art had existed for several decades, you know?
Yeah.
And this was with respect to a problem that the industry was looking actively for a solution. And Judge Rader said, you know, you've got to be kidding me. If you look at I'm in the bottom paragraph here, the elapsed time between the prior art and the filing date evidences this was not obvious to try. Because if this had been obvious to try, somebody would have tried this years and years earlier.
Yeah, well, see, whenever the CAFC agrees with me, I think it shows evidence of keen insight and understanding that, you know, hindsight is, it sneaks in to things, you know, it's there because the examiner cannot exclude it from their mind, you know, because an examiner is well informed in the field, probably more well informed than most, because that's all they're looking at day by day, you know, and so they follow things incrementally, and by the time they look at yours, it's, well, sure, everybody's doing it. Yeah, but they weren't then. And that can be a record that shows it wasn't obvious. You know, it's absolutely the converse of what the examiner is proposing.
Yeah, so in this case, there was also a numerous possible combinations. So it just didn't fit with the finite number of possible choices to combine, leading it to be obvious to try in any event, because the breadth of the possible choices. But what I guess I'm trying to say is I would invite folks, because I get emails on secondary considerations. I know, John, you did too. We had a whole lot of questions on secondary considerations the first time we did this, and then we got a lot more questions via email after we did this. So what I would suggest, anybody who's, you know, trying to wrap their heads around this and making good arguments and so forth, don't just look at case law that specifically deals with secondary considerations. There's an awful lot of good case law that you can draw arguments to and analogies to outside of the strict secondary considerations cases. And I would start looking at cases dealing with obvious to try, because there is going to be some of these cases like Leo where you can point out to very specific facts that will be useful for you. So now let me jump back to where we were in the place we were at, slide number 9 here. Oh no, where were we? We were there. Then were we here yet? No.
No, we weren't here yet. We were in the slide just before that.
Okay, so we were here. Okay. So
yeah, the last thing I would say on secondary considerations, and this was the point of a couple of email questions that I got years ago in a re-exam effort, probably 6 or 7 years after a patent had issued. It was challenged in re-exam. It was widely, it was challenged in a re-exam, but the technology in it was widely adopted, as they say, not by licensees, but by would-be and ongoing infringers. And the features in the patent were specifically the features that had been relied on for the commercial success. And so the question was, can you rely on the commercial success of others? And this is a question of those who, they're independent inventors, or they're relatively small out of the gate, but their technology has been taken by those who are well out of the gate, and are widely promoting it. And the question is, can you use their success as a basis of secondary consideration? And the answer is you can, if you can establish the nexus. And establishing the nexus, it may take a little work, it has to be logical and fit together, but in that particular instance, it worked. I think the irony was that, but for this being challenged in re-exam, which gave the patented technology years to get out there and into the industry, these secondary considerations were not available during original prosecution, didn't exist. But after 5 years and then during the re-exam, absolutely. By then, I had solid secondary considerations to write up, and it was commercial success and long felt need, and it won the day.
Yeah. So now the next here is just what we all have come to know is that secondary considerations must be taken into account. This is, the examiners have to do it, although they really don't like doing it. And some examiners will tell you that when you argue secondary considerations, they know that they've won, which is just, I find, rather idiotic, because it is a requirement. It's in the MPEP. And let me just pause there. You know, I get a lot of attorneys telling me that examiners say just some of the darndest things to them. And, you know, if you're working with an examiner that will say, you know, look, I haven't issued a patent since Alice, and I'm not about to start with you, put that on the record. You know, these types of things have got, because thinking that you have a relationship that can be saved with that examiner, or that you have a relationship with that art unit that can be salvaged, I think is a fool's errand at this point. I mean, look at the allowance rates at some of these art units, and it's likely speed driven. You know, these people are not just telling you what they think. They think what they think because they're still there, because they're comfortable working in an environment where there's no patent for you. You know?
Well, sadly.
Yeah, and Gene, you know,
Yep.
this is what drives me every day. But absolutely, I think it's important before you make any argument to take a look at the examiner's allowance rate, and particularly their allowance rate on issues that you're dealing with. Because you're right, there are absolutely examiners who are just more difficult than others, and it's important to know that.
Yeah, I mean, examiners are there to defend the public interest, not to stop the process. You know, they're meant to guard against you getting something patented that you didn't bring to the table, but and that you've adequately described it and so forth. But some examiners think the public interest is better served by not granting patents. You know, and that's funny. You know, if you talk to an examiner, current or former, and you say, do you work for the patent granting authority or the application denial authority? You know?
Yeah, you know, and that's the thing. And I don't know, you know, this may be a conversation to have over a cocktail perhaps, but, you know, in the patent bar course that John and I teach, we see a fair number of former examiners who are, you know, been there a few years, and now they've left the office, and now they're going to become patent agents or what have you. And I always ask them, did you work for the patent granting authority, or did you work for the patent denial authority? And just recently, a couple of them, they looked at me and they started laughing, and they're like, oh, well, we work for the patent denial authority. And I said, what are you talking about? You're killing me. And they said, why do you think we're here?
Yeah.
You know, and that becomes a real problem, because a lot of the examiners that would otherwise be disposed to, you know, calling balls and strikes, just don't want to work for an organization where they think they have to deny everything. And so you wind up with, in some of these art units that are the terrible allowance rates, the only people who stay there are the people who are comfortable denying everything. But that's a different conversation, probably for a different day. And this is we have a couple slides here on the Nexus requirement. We could probably just go past that. We talked about this a bit, but you have the sites here in case you need any information on the Nexus requirement. And I want to get to this case, because this is a case that John and I know, you know, very well, and we can talk about on a very detailed factual basis, because we both have represented the inventor in this case. I wrote the original patent application on the claims that wound up being lost this summer. I did not prosecute the application. I wrote the provisional and I wrote the non-provisional, and then others prosecuted and wound up getting the claims that wound up being declared obvious by the Federal Circuit. But this deals with a wakeboard.
But Newman disagreed.
Judge Newman disagreed, and you know, there's this problem. It seems that some, and everybody on the call is probably going to be familiar with this, right? There's this problem that some examiners, some PTAB judges, some district court judges, and even on the Federal Circuit, there will be those who think that certain inventions are just too trivial, regardless of what the innovation is. And I think that that's what's going on here with this wakeboard, because, you know, being a big guy who has tried sometimes to get up on a wakeboard and then just be dragged around mercilessly and never get up on the wakeboard until my arms get too tired that I can't hardly get back up into the boat. I saw this invention and I said, you know, there's something unique going on here, and there is. This wakeboard allows everybody to participate, and it planes, and you can get up on it, and he's got video showing, you know, 6'8", 325-pound lineman doing it, and an 80-year-old frail grandmother doing it. So there's something here, and the problem that Judge Newman pointed here to is that it seems that the panel just didn't follow the rule of the Federal Circuit, which is the rule is that secondary considerations is a primary consideration. It is not look at the first three and then does the secondary considerations counterbalance the first three. No, that they are part of the primary inquiry, and I have a case site that will show that coming up here. I think on the next slide we can just push to that. I mean, this is the en banc decision where they say that the majority decided this, but somehow there is this view that in Zup versus Nash and in some other panels are just not following Apple versus Samsung.
The question is secondary considerations a primary consideration when you're assessing obviousness, or is it a balancing consideration when you're assessing obviousness? And it's clearly part of the original inquiry, because most folks would say, well, no, you look at the Graham factors, make a decision on obviousness, and then go look to see if anything balances that out. And that's not how you do it. You look at your Graham factors, you make your determination in light of the secondary considerations. That's how you arrive or don't arrive at a prima facie case of obviousness. You consider it at the outset.
Yeah, so this is gonna, I think, I don't know how long it's gonna take, but it's gonna, I think, come to a head. It's got to come to a head at some point. I think that there's some folks on the Federal Circuit that are interested in this issue. They're interested in addressing this issue maybe head on with respect to its implications under a KSR universe, and maybe there'll be some need for the Supreme Court to weigh in on it. I don't know, but there seems to be an awful lot of disagreement among the Federal Circuit, even though the en banc majority has spoken on this particular issue. So I don't know what we can do other than highlight this issue for you, give you some case sites, and continue to give you some hope that keep making these arguments.
Yeah, the quote there from Strataflex is just gold. It's to be considered. This is secondary considerations as a part of all the evidence, not just when the decision maker remains in doubt after reviewing the art. It's part of the consideration in its entirety.
Yeah. All right. So moving to the next, this is one of my biggest pet peeves in the entire area of obviousness, is this role of common sense, because as it turns out, common sense is not particularly common.
And it's not a reference.
And it's not a reference, because that's the other thing too, is there is no such thing as a single reference obviousness rejection. They don't exist. They can't exist. A single reference rejection is a 102 rejection. You have to have, for obviousness, it has to be a combination. Now that combination can be what is known by somebody of skill in the art, but it has to actually be known. There has to be another piece that when you push the decision maker to their proof, they can come up with something. This is not wave a magic wand and that additional missing element suddenly appears. So what is said in the MPEP 2141 is incorrect based on the ruling in Arendi versus Apple. So in Arendi versus Apple, they essentially cabined the perfect web decision to the point where that is now an exception. So the issue in Arendi is, did the board misuse common sense? And the answer was yes, they did. And I think I have, so there are 3 caveats to using common sense from Arendi. First, common sense is generally invoked to provide a motivation to combine, not supply a missing claim limitation. Second, the reason that it was allowed in perfect web to supply what was missing was because that was unusually simple. And in fact, Judge O'Malley and Arendi pointed out that perfect web was the only case that was ever allowed to happen. And if you recall the facts in Perfect Web, it was you had an email list, you sent the email, that which bounced, you tried to resend. That was it. The step of resending was what was missing. But that was so simple and so commonplace that it was believed that anybody would try and resend once.
Yeah, and the other message about this is when there are many, little quotes and sum and substance kind of observations you can make about a case, but you always have to consider the context in which they were offered in a case. And so where Perfect Web supplied something, you had to go back and, oh, I get it. You're just remailing something that bounced. That's the threshold of triviality where that can come into play. It's not a wholesale statement that, well, when things are missing, you just kind of wing it.
Right, and that's what examiners try and do. And so you will see examiners do just that, and you'll wonder, well, why are they doing that? They're doing that because 2141 tells them exactly to do that.
And it's wrong.
And it's wrong. So you need to be mindful of that and cite Arendi and get that on the record. And then the third caveat to common sense is it just cannot be used as a wholesale substitute for reason analysis and evidentiary support. This is not about doing away with explaining yourself. So in this case, Judge O'Malley said the board's utter failure to explain themselves is problematic. Really, yes, it is. It's extremely problematic. So, not to say that you couldn't have gotten there, and not to say that this would have been something that should have been non-obvious, but on the facts that were presented, it could not be obvious because not all claim elements were present in the prior art. It was just that simple. So Arendi has got to be in your toolbox, and you have to know that examiners are doing what they're told to do when they seem to be violating it. And but make sure you get that of record. We were about halfway through here, and we want to make sure that you all know that you can send us questions in, and we'll get to them. We have some slides coming up here in a minute that will deal with the questions that we got in advance. But the next slide here, we can probably go through this quickly because it's not a real big issue. John, and every time I mention it, he laughs because it's not an issue that comes up very often. But when it does come up, it kind of catches people by surprise because it's inherent obviousness. And number one, it says what inherent obviousness is. It's when a new use, new function, or an unknown property is inherently present, that's going to make it inherently obvious.
Well, this is like double patenting. There's two types of double patenting. There's same invention type, and then there's obviousness type. And I think inherent obviousness stems from, well, if you can't get a patent on something because you recognized a new property in it, then that's a prior art scenario based on inherency. Then you ought to have its close cousin, the inherent obviousness. But I think is a much bigger leap than going from same invention double patenting to obviousness type double patenting, because inherent obviousness means not only is something unknown, but there's an obvious variation on the unknown thing.
Yeah, and so the number one sets the premise, and 2 through 6 are all about, well, but it's not here, and it's not here, and it's not here. So the good news is if you get an inherent obviousness rejection, the case law is going to be on your side. It is extremely difficult for these rejections to stick because it's not that it may result, it's that it absolutely positively has to result. And an invitation to investigate is not enough. And there's an extremely high standard for this, and assumptions are just insufficient. And then the last one, I love the last one, that which is unknown cannot be obvious.
Like that had to be said.
But it does need to be said, right? I mean, because we know that, like in that one case, the In-Ray omeprazole case, right, where they came up with the buffer
and the coding.
And the coding, and it was the only people who knew it was a problem to begin with were the inventors. right? Well, once you know it's a problem and then they tell you what their invention was, oh yeah, that was trivial. Well, it couldn't have been obvious because you didn't even know it was a problem, right? So if the inventors are the only ones who knew it was a problem to begin with, the solution cannot be obvious, and but you see those cases all the time. So that memo has not gotten to the defendants.
Right.
So that memo hopefully will continue to get to the patent owners. So we can go by this. Now, this is one, I'm going to let John lead this, and I'm going to try not to snicker. We got a question about language adapted to and then configured to. So we have a slide about adapted to, and then we have a slide on configured to. And John does use this language, or has used this language, right?
Well, yeah, I mean, when I was at the patent office, I was examining in automatic transmissions, clutches, and ancillary controls. And so you often would have something that was mimicked out of, say, a watch movement, an extremely light torque kind of device. And then a similar device was being employed in an automatic transmission for a piece of earth moving equipment. And the way to get it out of the realm of a watch movement was to say it was adapted to transfer a torque in excess of 400 or 500 Newton meters or something like that. And yeah, the examiners accepted that, because that was well understood to separate you. And likewise, if you have something that is only useful for coal mining, but it replicates something that a surgeon might use to remove plaque in an artery, pretty clearly coal mining, despite similar structure or something and purpose, is not illustrative of what you might accomplish inside a human body using a catheter. And so adapted to and configured to shows up from time to time, but it's always in context. And the heartburn that Gene has about this is left-handed and right-handed operation. And
okay, so wait a minute, hold on. The context we have, okay, you probably all know we teach this patent bar review course, right? John created it, and I've been teaching it now for almost 19 years. And there's this one question in this.
He's still hung up on it.
And there's a left, and many of you have taken this course, and you maybe remember this question. And there's a left-handed scalpel. There's a right-handed scalpel in the prior art. So the guy invents a left-handed scalpel for left-handed only surgeons. Right. Okay, so in my world, because I deal with software and we can't get patents on real innovation. So in my head, I can't for the life of me think, how can you get a patent on that? I mean, the right-handed scalpel is known, and you're going to get a patent on a left-handed scalpel?
Yes, Gene.
Oh my God. Oh my God. This is horrible.
And it's because, and I've walked Gene through this.
I know, and I refuse to. I say, look, I refuse to do this question anymore. You need to talk to John.
Yeah, and the reason is, let me just give you one example, and then we won't belabor this anymore. But I got into this in the fishing reel art, and you have a right-handed world for fishing because, by and large, most people are right-handed. And to adapt a right-handed thing for left-handed operation is not something you would do by virtue of it being operated by a right-handed person. And it's not a mirror image. It's something that is designed for right-handers being adapted for left-handed operation. It's like a rifle I have. The bolt is on the wrong side for left-handed operation, but you can still use it left-handed. It's the nature of things. We live in a right-handed world, so adapting it for left-handed use there's nothing obvious or intuitive about it. But for Gene,
but why is there
a struggle?
I mean, look, I'm happy that anything can wind up getting patented. I just wonder whether that type of thing winds up surviving. I mean, because you did get me the last time we talked about this. I did start to see, with the fishing reel, and how it turns and everything, and the left-handed, right-handed, and it maybe doesn't seem quite as intuitive as I guess I had originally thought. But do you think that today you still get those kinds of claims today?
Well, I think that the language adapted to and configured to, whether you get the left hand, right hand difference, I think depends entirely on what the object is. Left and right handed scissors are obviously a mirror. one of the other, but something that rotates one direction and rotates in the same direction, but still for a left-hander, you know, that kind of thing. Yeah, that's quite different because the balance is entirely different. But the point is, in this adapted to and configured to, it's contextual.
So now, and that's where you got me when we with the fishing reel thing, because the balance is different, and it. But now, so that I'm asking, that has to go into the specification.
Absolutely.
Right.
Yes, yes.
And then now, when you would be, because you would still get an obviousness rejection from the examiner.
Absolutely.
Okay. Now, when you would go and I assume you would have to interview that type of a case usually.
Unless you'd worked through with that examiner a few times the left hand, right hand protocol. And it was, this happened to be fishing reels because it wasn't a mirror image. It kept rotating the same way, but now you're holding it differently and it's balanced differently. So now you have to add weights somewhere else to get smooth operation, which in a right-handed thing would make it vibrate.
Right. Okay. So there needs to be some kind of, I guess, in some way unexpected, and then we get back into your over KSR. So
yes.
that works, because the whole thing with adapted to, if you look at and I've got some MPEP sites here for you, and you read the MPEP on this, it's all about the context of the technology. It will sometimes be a limitation, and sometimes it'll just be superfluous language that doesn't limit the claim at all. And so it really goes back to the technology. So, and I guess in a situation like that, sometimes would you go with a prop?
Well, the problem with going in with a prop is that you might get stuck maintaining that exhibit for the enforceable life of the patent. So go in with a prop, but also go in with pictures or a little film clip or something that shows what you were demonstrating to the examiner, so that it can be an electronic record or a paper record, and you don't get stuck having to maintain the exhibit for the next 20 some years. So props are good, and in the fishing reel area especially, props are great because when you spin something, you get a gyro effect, and it creates a torque on the device. And so right-handers get the torque going one way, left-handers get the torque going a different way, and it's a profound thing. And it's
yeah, and this gets back to the thing where, you know, if there's that kind of you know, physics involved, you need to have the physics and the
yes.
math and the angles in the specification.
Yes.
All right. So now configure to was also a question that we got. Now, you might think that adapted to and configured to really are the same or sound the same, but interestingly, where you find the word configured to mentioned in the MPEP is it's mentioned in sections that specifically are talking about 112F. Okay, so and the general rule, you know, is if you don't use means, there's a presumption that you're not going to invoke 112F. But Williamson sort of undid that and made it a much easier presumption to overcome. And now there's this three-part test that the examiners apply to determine whether or not the claim is invoking 112F. And the second prong of that test uses configured to specifically as an example. Mm-hmm. The other place in the MPEP where you will see the language configured to is in the 101 cases and analysis, specifically where you're talking about like software or signals configured to receive, configured to send, those kinds of things in the patent eligibility cases. So this is going to be context as well. It's going to be technology driven. You'll probably use it in some of your high tech, maybe software types things. But I wanted to highlight for you that the MPEP talks about this in 112F terms in the way that they do not talk about adapted to.
Right, right. And again, it's examiner to examiner, but in the mechanical realm, these terms have, you know, particular meaning in context.
Yeah. All right. So these are the KSR rationales, and, you know, they all deal with predictability or reasonable expectations of success. As you know, 3 does not, but it's by its very definition, you're using the same technique to improve in the same way, which is very predictable. Looking at the time, we're not like so crunched on time, but I want to make sure we get to a couple of these slides. So I'm going to kind of cherry pick some of these things And I want to make sure I start with the one where we got the question sent to us. So we get to this, and we got a question about analogous art. And how do you argue with examiners when they're combining things that you don't think are really from the same field of endeavor?
Or they're just flatly inapplicable. And I think it again, the examiner, especially in the mechanical and even the electrical area, they're just looking for similarity, and then they kind of pile it all together. And the one I thought was quite funny was an examiner it was a lightning arresting system on an aircraft, and he had cited a lightning arresting system for a substation, land-based, and it was made of cast iron and was bolted to a cable that was attached to a heavy iron device buried in the earth. And I said, really? You're going to put this on an aircraft? And it was just, it looked similar. And so, examiners can be talked out of rejections.
He was going to tether this aircraft to the ground.
Yeah, I guess with a large piece of iron somewhere. And so examiners can be talked out of it, but you have to explain to them why it doesn't make a lick of sense. And again, it's the mining device that the examiner suggests could be put on the end of a catheter. It's unlikely there, examiner, that you're going to use a coal mining machine to go up somebody's artery.
Yeah, we had an examiner one time. This is many, many years ago. It was a catheter invention, and they used forceps as in a combination for obviousness, but it just wasn't any forceps. They were equine forceps, and it was like, really, and it was like we took turns just like quickly drafting something up that then we quickly ripped up and threw away because we weren't going to respond to it. We just were joking around. It was like, you would actually kill the person if you used anything like that. Are you kidding me? Yeah. So and what comes to mind here while I'm thinking about this is, over the years, I've gotten to know a number of examiners, and John's son is currently an examiner, and he used to work for me when he was in college, and I know him really well, so I talked to him, and I talked to a bunch of other examiners, not about the cases they're working on, but some of the things that they like to see and what isn't particularly helpful, those kinds of things. And one of the things that every examiner I've ever talked to over the years says, and even the old timers that I know, is when an attorney says the examiner clearly doesn't understand the art or doesn't understand the technology.
That's unhelpful.
That is just unhelpful. Now maybe it's true. Maybe they don't.
Forget truth.
But don't say it.
Yeah.
Because you want to upset an examiner, that is like fingers on a chalkboard, because they're there trying. They only get but so many hours, and I just asked the patent office what the number of hours is, and the average, and this is not maybe particularly helpful because it's a pretty widespread, but it's 21. I think it says 21. I just published it. 21 hours per case is the average. Now that goes all the way down to 13 or 12 or 13 and all the way up to I think 35. And it depends upon the examiner's seniority and the technology that they're working in and all those kinds of things. But, you're talking about not an awful lot of time these examiners are getting to, read the application, read all the prior art, look at, restrictions, send the first office action, talk to you on the telephone, consider your remarks and responses back, do a final office action. If you want to have an interview in there, interview after final, all these things, there's not a lot of time. So, and they work in the same field over and over and over again. So, understanding what they're looking at usually is not the problem. Now, maybe they're being forced to work quicker than they ought to be able to work. That may be the problem, but you're doing nobody a service by telling them, examiner, you don't know anything about this field and you should go back to school, because I know you don't say and go back to school and learn this, but that's what they hear.
Yeah, telling them they don't get it is not persuasive. Rather, help them appreciate you know, how difficult it was or how illogical your solution would have been to one of ordinary skill, and the insight it took to arrive at what you're presently claiming. You know, argue based on the fact that they know what you can communicate to them.
And then the other thing too is interview. You know, I look at the number of interviews that are done and the number of hours of interviews that are done versus the number of applications that are filed and prosecution that occur every year. And it's like, why is the bar not interviewing every single case? I mean, because one of the old timers I know told me one time, he's like, every time he would get paper from this one attorney, he would just cringe, you know. And then that attorney came and he did an interview with them, and they hit it off, you know, like in person it was, you know, they became sort of like, you know, fast friends, like colleagues kind of thing, you know. Yeah. And it was like he didn't, every paper he got from that attorney thereafter, he realized that, okay, this guy's not a jerk. It's just he writes like an engineer, you know, he's matter of fact, you know. And so, and I know you don't meet these examiners in person anymore usually, but talk to them. You know, you can do these meetings, WebEx meetings or whatever platform they're using now, and that's a missed opportunity if you're not using it, I think.
Yeah, I interview.
So Gene,
go ahead.
Go ahead,
Megan.
Megan.
Go ahead, John.
No, go ahead,
so
Megan.
I have to interrupt here. You know, you have a thing with adapted to. I have a thing with saying that everyone should interview, and I think that it's true that with most, in fact, the vast majority of examiners, you should. But just looking at the numbers, there are some examiners where, I mean, you know, there may have been hundreds of interviews in their career, and they've only ever granted an allowance after a handful of them. So I would say that's true like 95% of the time, but that it's important to check on the statistics because interviews take time. You know, it's a lot of extra attorney fees.
That's a good point.
It's true like 90% of the time, but not every time.
That's a good point. I mean, there are some, and we could probably know off the top of our head which art units those examiners are in.
Yeah. It usually corresponds with that.
Yeah.
But if I could also jump in since we're nearing the end here, you know, the other thing along these lines is that I think it's really important with any of these arguments that you do some research that's specific to your examiner. So, you know, Gene, you mentioned earlier that if you're dealing, for example, with secondary considerations, don't limit your case law research to just secondary considerations. I would go even further and say don't limit your research to just case law. So there are tools, you know, LexisNexis Patent Advisor has a tool called PatDoc Search that allows you to search the full text of ISW documents to find arguments that have been successful for others. So for example, if you want to know if somebody has ever argued secondary considerations against your examiner and won, you can do that. You can see you can even see which secondary considerations they argued and how they argued it. And I think this is really important because I know that we've all been in a situation where the case law was unquestionably in our favor, but the examiner didn't care. But presumably, hopefully, the examiner will care if you can cite some of their own work in your response.
That's it. Yeah, they're most persuaded by their own past decisions, no doubt.
Yeah. So I think that is very, very helpful because you know they're people too. You know, if they decided it this way in the past, they're probably not going to want to think that they were wrong then. So
right.
Yeah. So in the time that we have remaining, I'm trying to look and see what we could accomplish here usefully. I mean, we could say, you know, obviously here, the beginning of obviousness is just about expectations of success. So we have a couple citations here, and we have a whole bunch of slides. We've got about 15 different slides here. All of you are going to get copies of the slides. If you want them right now, you can download under the handout section on the GoToWebinar panel, all the handouts. They'll be sent to you along with access to this webinar. But we've got a bunch of citations here. So about expectations of success. And the last one here, citation here, is in this 2013 case, is the expectation of success much actually matched the goal of the inventor.
Yeah.
You know, this is not the examiner's idea of what the successful goal was. What was the inventor actually trying to accomplish? And then, you know, this is an oldie but a goodie, is there no per se rules? You know, there's no per se rules on obviousness. And then combining prior art elements. Throughout these remaining slides, we have sprinkled in, this is what, if the examiner is going to use this particular KSR element to reject you, this is what they have to show you. This is what they have to create. And then it just makes sure that they are actually taking into consideration all of the elements.
Yeah, what you'll find, especially in dependent claims, is a lot of hand waving. You know, the examiner doesn't have the elements that you're claiming, and they just say, well, to supply them would be obvious. Well, actually, no, examiner, that's not the standard.
Yeah, no, it's not. And you don't want to get into, because remember, if you spent all your time only arguing about the independent claims, then all of your claims are going to rise and fall on that one claim. If you allow a representative claim to be the one that is going to be the end all be all, then on appeal, that's the only one they're going to look at, because that's the only one you argued. So you've got to argue all of the claims, including all the dependent claims. And that maybe is more of an issue when you get to the post-grant challenges and so forth. But every claim matters.
Yeah.
Then teaching away, we have, you know, a bunch of sites there. We did the analogous art, simple substitution. Again, we have this here. Let's get to this slide and see if we can talk about this for a second, because I added some stuff here. The In re Con case, that was a decision by Judge Lynn, and it actually did not go very well for the patent owner in that particular case, but the language he used is really helpful for patent owners. So he sets out really good language, and the reason that case is important is because the Supreme Court in KSR cited it with approval. You know, in KSR, they said that there's a variety of factors that are going to need to be considered in order to determine whether there is an apparent reason to combine. And then right after that, they cited with approval In re Con, saying, and this parenthetical actually appears right in the middle there, that parenthetical appears in KSR. Rejections on obviousness grounds cannot be sustained by mere conclusory statements. Instead, there must be some articulated reason and rational underpinning. So that rational underpinning language comes from Con and was picked up by the Supreme Court. So you got to go back and read Con. If you're not familiar with Con, I think you need to become more familiar with Con, because if you read it, I think you're going to be surprised. Now, it talks obviously about teaching, suggestion, and motivation, and that stuff is not, you know, the end all be all that it makes it out to be. But there's some really, really good support and language in Con. Now, looking at the clock, I see that we're about 2 minutes from done. So what I'd like to do is we can pause here and get to our final thoughts. So Megan, I'll start with you. John, I'll ask you for your final thoughts. What is it that you want, Megan, people to remember as they leave the webinar today?
So I can't overstate the importance of knowing your examiner. Know how many 103 rejections they issue and what happens when they issue those rejections. Confirm that it actually does make sense to interview them about it, and research their body of work to shape your response strategy. I think that nowhere is the PatDoc search tool more important than for 103 rejections. So know who you're negotiating with.
All right, thanks, Megan. John, your last thought. What do people need to remember today?
Well, understand that a 103 rejection is, you know, the most common form of rejection because it's what the examiners have to work with. And understand that a prima facie case of obviousness is not the end of the road. It's the beginning of your articulation as to why this thing is not obvious. That's all it is. It's them putting a marker out there. Prima facie doesn't mean it's over. It just means it is what the rejection is until challenged. You know, it works until there's an alternative presented. So present that alternative and carefully read the references to help the examiner understand what they missed.
Well, thank you both, Megan. Thank you, John. And thank you all for being here today. My final thought simply is that the law of obviousness is getting more and more complicated, and so much of it folds over onto itself, and it's not a neat pigeonholed area. And it's complicated. And 10 years ago, 8 years ago, before we started to get into the 101 complexity, call it chaos if you want, I really thought 103 was going to be the next big issue. So as we start to see 101 begin to show signs of resolving itself, I think we're going to start to get past 101 rejections and then start to see in an awful lot of important areas. 103 is once again the big ticket item. So, and it hasn't matured very much over the last 10 years because so many of these critically important areas have been getting kicked out on 101. So a lot of development still yet to do, and we can do better, I think, if we realize what the target is when we file these applications and just don't let the examiners get away with these conclusory statements. So hopefully you got a lot out of this. I appreciate you coming back for this encore presentation, and thank you to LexisNexis, and hopefully we'll see you at our next webinar with them on November 29th. Have a good rest of your day.